question is that section 31 of the standing order be suspended. All those honorable members in favor, please say aye. And those against, please say no. We think the ayes have it. Honourable member for Christchurch East.
Mr. Speaker, I thank you for accommodating me with your suspension of these standing orders, because we find ourselves in a position where, based on the expediency and what makes good common sense, sir, both bills were examined and considered by the same standing committee, the same sitting standing committee, as one because of the interconnectedness and the relationship between the child protection legislation and the child justice legislation. So having considered in full the import of the child protection legislation over the last couple of days, we then were met with a situation where we needed now to fully consider the import of the standing committee in relation to the child justice legislation. And as we're actually literally debating the report itself, it was necessary to make the amendment to the standing orders to allow me to have the same time effectively as my friend who spoke before to properly ventilate this important piece of legislation. Sir, I believe gratitude is a must. And before I start into the substantive provisions of the bill and the parts of the report which led to amendment of the bill, I need to start by thanking the persons who were instrumental in drafting the bill, in shepherding the bill, in having my back at what was an exceedingly difficult time for me, that led ultimately to a lot of the provisions and considerations in the bill. So I want to start by thanking the CPC's office, because it was no easy task for the Chief Parliamentary Counsel to have to deal with the two parallel pieces of legislation that sought to overturn centuries, actually the entire historical perspective of Barbados in relation to protection of children and justice as it regards children. So these two pieces of legislation effectively overturned the entire apple cart. It drew a line and said we start again in how we look at our children, how we look at their care and protection, how we look at dealing with them once they've come to the attention of the justice system. I want to as well thank the consultants. Because I'm calling their names in a positive light, I would like to thank Ms. Faith Marshall-Harris. And I also want to thank Heather Stewart, who was on loan to us for the purpose of drafting and making sure the content of this legislation accurately reflected best practices. I want, sir, as well to thank my friend, the MP from St. Thomas, the Honourable Member of St. Thomas, who was there hands-on in lending her expert opinion in relation to both pieces of legislation. I want to thank the Honourable Member for St. James North, pretty much under whose stewardship we started to redirect and reimagine child justice legislation. If I'm being honest and frank, sir, in 2018, I think there was a draft of child justice legislation by the former administration, but it was never dealt with, and it expired with the term of their governance. My friend, the Honourable Member for St. James North, picked up that baton and started running with it when he became the Minister of Home Affairs, and pretty much decided to almost scrap the entire legislation and go again, because we didn't want to just plug holes. We didn't want to just deal with the issues that were present and that we identified as problems at the time. We wanted our legislation to be forward-thinking. It's not legislation for now, to deal with a now problem. It had to be legislation for the future. Can we reimagine justice as it relates to children that is not just suitable for now, but suitable for anything else that might come after that? So I want to thank him unreservedly for the part he played in starting the ball rolling. He created a situation, sir, where I came on to a wicket that had been prepared, and it was possibly, sir, at first-class match standard. But then we had some further discussions, sir, and we decided that first-class match is okay for first-class team. But if we want to be international, then we must be aiming to have an international pitch. And I am satisfied, sir, that the legislation before us now is that international pitch on which we can play a game that benefits our children. I want to thank the probation department, who was a rock behind me. And I want to thank, sir, the former chair of the Government Industrial Schools Board and her team. She's no longer the chair. She demitted office a couple of weeks ago, but the rest of the board is unchanged. That board, sir, saw me through perhaps the most difficult point in my ministerial career. Everybody knows of what transpired at the Government Industrial School. Unfortunately, the baseline truth of it will never be known because, sir, we have to preserve the privacy of juveniles while they're in our care. And even if I have to hold lashes in some circumstances unjustifiably, when there is a real good explanation, but that explanation casts somebody else in a bad light, then it falls to my shoulders. And I want to thank the members of the board, many of whom are here today, for their steadfast support, for the messages late at night saying, don't mind that, we can get through this, for the messages saying, we got your back, for actually coming out openly in defense of me in some circumstances where they themselves got abused. I don't abuse in this parliamentary language, where they themselves got verbally abused and took a lot of heat for something that was not their doing. So we often don't understand the role of a board. The board at the end of the day is the minister's board. The minister appoints the board, he replaces the board. And quite often, sir, our interaction with the board is limited to reports or minutes, or if something catastrophic happens. I would tell you that I felt the presence of my board every single day when we were going through that ordeal. I felt their presence in my life. I saw their presence in person at the institution. And I think, sir, what helped me and helped the government to get through that difficult time was the strength, the diversity, the hands-on commitment of that particular board. I am very effusive in my thanks, sir, more than I would normally be, but because it's deserving. So I wish to thank, through you, sir, the members of my board, my stellar board, my sterling board, sir, for their support that led us all to this point. The last thing, sir, is an apology. I want to apologize for the absence of the principal of the Government Industrial School. Sir, I also, the chairman of the board, and my PS, who would normally be here now, but interestingly, before we rescheduled the debate to be today, we had committed to going on a tour of Tulsa, some correctional facilities, child justice type facilities in Tulsa, which has one of the best child rehabilitation integration programs in the United States. So that was set up. So key persons in our ministry, in the board, in the Government Industrial School, are presently now learning best practices, consulting on the right agenda, consulting on the right programs, sitting in on meetings with children, diversionary type meetings, a lot of the stuff that's in our legislation. They have gone to see that hands-on. So when we get to that point, we're not picking up the ball now and trying to go from scratch, but we would already have been seasoned and know the application and know how it operates. So that is why they're not here. I was actually supposed to be on that trip, sir, but I had to be here. But I thought it was best, rather than try to postpone that trip, that those who were not speaking from the floor all went represented, because at the end of the day, it is of utmost importance to me that from the time we pass this, we get rolling in as fast a way as we can. So having said all of that, sir, I now actually start. That was the intro. Oh, happy day. Sir, The committee did its work. The committee did a sterling job. I thank the Honourable Member for St. George North before, so I can probably thank her again, sir. No thanks is too much for her and her committee for dealing with perhaps the most sensitive thing that we've had to deal with as a government, and actually starting the change of a process that's going to take Barbados forward, the one of consultative legislation. Before the advent of these committees, 30 people in Parliament passed legislation. We debated it among ourselves. We would have gotten the best advice possible from consultants and from those in the field and stakeholders. But then when we came to Parliament, we debated in here, and coming out of here, legislation either was passed or it wasn't. If it was passed here, it went on to the Senate, and 21 other persons dealt with it. For the first time ever, sir, in the history of Barbados, we've had effectively what is an open consultation on legislation, allowing not just the recognized stakeholders, but also concerned citizens, fringe groups, anyone who had anything to say was allowed to come and tender their thoughts, their written thoughts, written submissions, and further, sir, some appeared to give oral evidence or to ask questions and be guided by the committee. This is a first for Barbados. It is a first. And following that entire process and the report that came out that detailed the full gamut of the consultations and the lengths to which the suggestions by the ordinary Barbadian or interest groups were accommodated into the legislation, I believe this is probably these two pieces of legislation are probably the most fully consultative pieces of legislation in the history of Barbados. So this is not, at the end of the day, this is not Wilfred's, Abrams's child justice bill or Humphrey's child protection legislation. This is the child protection legislation as consulted with the people of Barbados. This is the child justice legislation as consulted with the people of Barbados. What do the people of Barbados have to say? My friend, sir, from St. Michael's South already went through in detail the parts relevant to him. If I nutshell it up front, the major concerns in relation to the child justice legislation were, I think, the age of criminal responsibility. There was also a factor relating to the UN Charter on the Rights of the Child. And then, sir, there was the issue of diversion. What does diversion mean? How is it done? What's the best way to do it? Is a model that we're following the best actual model? So let me start by dealing with the charters and international treaties that cause some concerns for persons. Now, an interesting thing happened, sir, before the consultative process, before the select committee. I had cause to sit down with a number of persons, sir, who were firmly against, and people, prior to this consultation, people drew no distinction between the two pieces of legislation. It was the child protection and child justice legislation. They said the child legislation. So one was the next, which was the next. And the conflation of the two pieces of legislation caused some confusion to people. They are, while they are related, sir, they are as different as night and day. Because the child protection legislation focuses in the main in trying to identify children who have issues that should be of concern to the state from earlier clock, and trying to put those children on a guiding path that they never come into conflict with the law. The child justice legislation necessarily concerns children who have come into conflict with the law. So one focuses on the holistic, how do we best structure and operate our country, our social services, our schools, our programs, all our support systems to keep the children away from conflict with the law. And the next one, my own, is more, well, we didn't manage to keep everybody away from the law. Some have come into conflict with the law. how do we best deal with them to make their outcome as positive as possible and not prejudice them in the long run. So that's to explain the difference between the two pieces of legislation. However, we did, sir, in doing this, have to toe the same lines in relation to certain treaties. Sir, at the beginning, the major treaty of concern was the one concerning the UN Treaty concerning the rights of the child. And as I said, I had this conversation with some well-meaning persons who were convinced that at the bottom of it, the subtext of this was that the international bodies wanted to create a framework that would promote homosexuality, promote gender issues, promote gender augmentation, promote all those things. That was all right. Both pieces of legislation were to allow, had at the root of it the possibility that somewhere in there, the government will sign on to something saying that international bodies or the state can actually decide the gender of a child or help a child to change its gender, to reassign its gender. So I had this conversation, and as one of the persons was telling me, you know, Abrams, I support you on most things, but I can't support you on this. I can't support you and your government. This is clearly an agenda. I said, well, I happen to have been literally hands-on in the drafting of the child justice legislation. I literally went through every single paragraph, every single clause. I can assure you it's not there. They say, Abrams, you're being naive. So I said, tell you what, let us go through it line by line. And you point out to me the parts that are offending you. Then the person said, well, they didn't have a copy of it in front of them. I said, well, I happen to have it on my phone. I have it on my Surface Pro, and I have a hard copy in my bag. And I offered to give it to them. And the person then said to me, well, to be honest with you, I haven't read the child justice legislation. And it's probably more the child protection legislation we have a concern about. So maybe it's not yours. So I then said, okay. I happen, with my good friend, the Honourable Member for St. Michael's South, I happen to have been hands-on in the drafting of his legislation. We lean, in this cabinet, we lean on each other for our expertise. If I have a social issue and I want some advice, I will call him and say, my man, I don't know how to deal with this. Even as a lawyer, sir, of many years standing, if somebody wants to ask me something or somebody comes to me about a labor issue, I will refer to my friend, the Honourable Member for St. Peter. We lean on each other. So my friend for St. Michael's South, in drafting his legislation, said, look, I want you to keep your eye on this for me. I want you to be involved in drafting it. I want that it runs parallel to yours. I want that at the end of the day, we have no issue between the two pieces of legislation. And I said, sure. So I was able to say with all the confidence in the world, well, I was involved in drafting that one too. And it's not in there. This was borne out, sir, in the deliberations in the Select Committee. I think it is necessary, sir, because I still hear people rumbling. I think it's necessary to actually say this again. The Prime Minister said it last week, but today is a different day. It might be different people listening. The bulk of the issues dealt with in detail by the Select Committee had to do with the fear over what our treaty obligations are and if the government is eventually going to put itself in a position where it can reassign genders to children. That was the bulk of it, sir. The nitty-gritty details that are really interesting and novel didn't even come up. Everyone was so caught up on this one thing, and it was being fueled by certain interest groups, sir. And I dare say there's some people who were well-meaning, who took their guidance from others that they trusted, but there's some people in this, sir, who were activated by malicious interests. There were some players in this whole drama who had another interest to serve. They brought people in from overseas who came to Barbados and stood up on platforms and talked foolishness. What if? And if in 20 years then, and you don't understand what's coming next, and it might not be apparent now, but there was nothing tendered. There was nothing tendered of substance, sir, that impugned either of these two bills as they stood. So let me, for the sake of setting the scene and dispelling this one, because it came up in mine as well, but by the time it came in relation to mine, it had been dealt with in relation to the child protection legislation a number of times, so the response of the committee was short and sweet. I don't want to say dismissive, but the response of the committee was short and sweet and led the person tendering it to understand that we're not taking that we've been there before. If Barbados is a signatory to a treaty, any treaty, I'm sorry that the Honourable Member for Christchurch South can't hear these words directly, but I'm just using an example inspired by him. If, sir, there was a treaty about the importation or the export of black belly sheep, and we signed on to it saying we protect the rights of black belly sheep, and every black belly sheep in Barbados that's exported has to be counted and then accounted for down the road, and we sign on to that. Fine. Where that treaty ends and we signs is the extent of our obligation. That's the extent of our obligation. We are bound by what comes before our signature. If somebody wishes to amend the treaty, as with anything else, you put it forward, you put forward the amendment, you move the amendment. But to amend an international treaty, sir, you require, I believe, a 2/3 majority of the signatories to the treaty for the amendment to go through. Even if the amendment is passed, every sovereign state has the right to say, I agree with the First Amendment, I agree with the Second Amendment, I reserve my rights on the Third Amendment, I don't agree with the Fourth Amendment. And therein you're bound by the First and Second, but you're not bound by the Third and the Fourth. So if, sir, if we ever got to the point where somebody was trying to force anything down our throats in relation to children, Barbados would have to put up their hand and say, I agree to that. We are not bound because we agree to something else. We have to specifically agree to that. And so I don't know about you, but I would never be raising my hand in a vote in any cabinet in which I am in, or further down the line, any parliament in which I'm in, to suggest that a child has the right to decide its gender. It absolutely does not. Once you are a child, you are incapable of making certain contractual arrangements. You know about that, sir? A child cannot enter into a contract. Further, if any government was to pass that in Barbados, well, that would probably be the last decision of that government in Barbados. They would never win another election. We ain't stupid. We're not stupid. The reassignment of genders of children, the deciding genders of children, anything gender augmentation, surgery, or whatever it is that you choose to imagine right now, let me say up front, it does not form any part of the Child Justice Bill. It does not form any part of the Child Protection Bill. It has never been discussed by the cabinet in which I sit, and I've been in the cabinet from the beginning. It has never been discussed, and it is not the contemplation of this government. I hope, sir, I have tried to be as unequivocal as I could be in my language, because I do not want to leave any room for any misunderstanding of anything that I have said. Let us, sir, now look at certain things in the bill. It sets the scene, sir, in relation to the legislation, first, for me to give certain definitions up front. Up front, sir, appropriate adult means a member of the family of the child or a custodian of the child who has attained the age of 18 years but excludes the parent of the child. The appropriate adult has attained the age of 18 years, not a child, right? So an appropriate adult, if there's no mother or father present, anybody who that child views as being a local parentis and has so been for a period of 12 months or more. So for example, sir, if I date a lady with a child, sorry, let's not pick me, sir, because I have a wife. I'm trying to find somebody here singing. If the Honourable Member for St. Lucie, sir, was to date a lady with a child, and he assumed rights over that child and treated the child as if the child was his own child for a period of 12 months or more, then he might be deemed an appropriate adult for the purpose of these proceedings as somebody that the child sees in the role of a parent. The Child Protection Authority means the authority established by Section 8 of the Child Protection Act. Child Justice Board means the boards appointed in accordance with Section 72(1). Sir, diversion. This is very, very, very important because this is going to be the substance of what it is that I'm going to be discussing, sir. Diversion. It means the removal of cases of children alleged to have committed an offense from the formal court procedures and the adoption of informal procedures in relation to such children pursuant to Part 5. And a diversion option means a plan or program with a specified content and duration settled in 3 levels under Section 36. Family group conference means a gathering convened by a probation officer as a diversion or sentencing option under Section 55. Child in conflict with the law means a child who is alleged to have committed an offense. Parent, sir. Natural mother means the woman who gave birth to the child. Natural father includes a man who has been adjudged to be the biological father of the child. Natural parent means a natural mother or natural father. Parent includes a natural parent or adoptive parent who has parental responsibility for the child. A person who has stood in local parentis to a child for a period of not less than 12 months and who has a continuing relationship with the child, or a legal guardian of the child who has custody or guardianship rights in relation to the child, but does not include a person acting as a caregiver on behalf of the Child Protection Authority. Reintegration Board means a board established in accordance with Section 94. Reintegration order is an order by the Reintegration Board. Secure residential facility means a facility described under Section 68. I will, just because it's interesting to do it now, a secure residential facility would include what we now consider as a government industrial school. So any such facility in the child protection legislation, they go towards care facilities. For us, remember, we're dealing with children who have come into conflict with the law, so it's a different setting. We try everything possible to keep children out of this formal setting, but so the reality is, at some point in time, you will need it. And so the secure residential facility is a facility of the type that we imagine or that the government industrial schools currently is. Sir, restorative justice means the promotion of reconciliation, restitution, and responsibility through the involvement of a child, the parents of a child, the members of the family of a child, and the victim and the community. I think that would suffice for now, sir. The purpose of this act shall be to ensure compliance with the UN Convention of the Rights of the Child. I dealt with that fully just now. Universal Declaration of Human Rights. United Nations Standard Minimum Rules for Administration of Juvenile Justice, also as the Beijing Rules. The UN Rules for Protection of Juveniles deprived of their liberty, and the UN Guidelines for the Prevention of Juvenile Delinquency. Sir, this act shall apply to a child who is alleged to have committed an offense and who, at the time of commission of that offense, was under the age of 18 years old. So, for the purpose of this legislation, there was some discussion as to what exactly is a child. Who is a child? A child, for the purpose of this legislation, sir, and the child protection legislation, is someone under the age of 18. This act shall also apply to person referred to in paragraph A, who at the time was under the age of 18, who attained the age of 18 before proceedings were instituted against him pursuant, and the proceedings have not been concluded. If my memory serves me correctly, sir, in the process of the select committee, there was some concern over the difference between under 12 years and a day for the purpose of criminal responsibility. A child under the age of 12 years is incapable of committing a crime. Standard. We've cleared it up. There was some anomaly. There were different rules under the common law. Some things were 12, some things were 14, depending on offense and other things, sir. Under our law right now, a child who is under the age of 12 is deemed incapable of committing a criminal offense. What does that mean? People don't understand it. They say, if the child did something, how can the child have not committed a criminal offense? Can it not be tried as a child? Under, Beverly, pass the water. A criminal action is broken down into two parts. This is Criminal Law 101 Crash Course, sir, the Crash Course edition. A criminal action is broken down into two parts and requires two things, two components. There's the actus reus, which is the action that is offensive. So if I slap my good friend from St. Lucie in his face, on the face of it, sir, it would appear that I've committed a criminal action. But also, hand in hand with that, sir, is the mens rea, which is the mental element. So, if the actus reus is there, but the intention was not there to do it, then I am not guilty of a crime. So, in this scenario, if I slapped him in his face, and it then came out, sir, that a centipede was crawling across his chin, and I knew he was allergic to centipedes, and if it bit him, he would die. And I gave him one good one, sir, not to cause him injury, but to dislodge the centipede. Then, although I slapped him in his face, no court is going to find me guilty of an offense because I did not have the mental element to hurt him. I was actually acting in good faith. I don't know if that explains that. It's important that you get the fact that there are two parts of it. Both parts have to be present, except in certain circumstances, which I'm not necessarily going to know, for the crime to occur. What the law says is that a child, by virtue of their immaturity and their perceived intellectual development at the age of 12, is incapable of forming criminal intent. Incapable of forming criminal intent. Now, why is that important? As I said, sir, my bill concerns persons who have come into conflict with the law. So if we have a child under the age of 12 who, for all intents and purposes, has committed what appears to be a criminal act, but is not a criminal act simply by virtue of the fact they haven't met the threshold of 12 years, then they don't fall to be considered under me. Then, from the time we ascertain their age, that child is diverted or dealt with under the child protection legislation, which is a whole different regime. They seek to get to the bottom of what caused the child to do that. They put the child in a care facility so that the child, whatever concerns the child had, can be properly addressed. But you don't divert them at all into the hearing process once they're under 12 years. So for the person who was concerned, who raised that one, if a child is under the age of 12, even if it appears they've committed a criminal act, that child will be dealt with by the child protection, under the child protection legislation, as a child in need of care and protection, and will never proceed under the child justice legislation. Having crossed 12 years and 1 day, that's a different story. What happens there? Where a child commits a criminal offense and the police are called, the police have to go through a process in relation to the child. They notify a probation officer, other welfare officers if necessary, and the child has a right to be represented at every stage. So, first thing you verify, how old are you? If you're over 18, this does not apply, you proceed on the normal criminal proceedings. If you're under the age of 18, you're deemed to be a child, and all the provisions in relation to child justice now kick in. The police interview you, sir. At the stage of the police interviewing you, the prosecution can, at that point in time, decide to not proceed with formal proceedings against the child. If for some reason all fails, and they decide enough is here, that if this was an adult, we would for certain arrest and charge the adult. They bring the child, sir, before the magistrate for the initial assessment. Another concern that arose was why, after the police proceeding, is the first stop a magistrate and not some other board to deal with the child. From the time you invite the magistrate into the whole play, then it is a criminal proceeding. That was dealt with, sir, completely and totally by the Chief Parliamentary Counsel. I'm not seeing it immediately here, but her position was effectively, and the position with which I agree. The initial assessment, which requires the parent to be notified, the child to be notified, probation to be notified, if the child is in need of some sort of psychological assessment, any person, including appropriate adult, any person who can have a bearing on why the child did what it did and what is the best course of action in relation to the child is invited now to come to this initial assessment. The magistrate has a wide jurisdiction as to who to bring and can bring whoever they want. The magistrate convenes the initial assessment, sir, in an informal manner. What they do sometimes now, sir, in respect to children and child proceedings, is the magistrate will come off the bench and sit at the table on the same level as the child. The child, and the legislation provides that the child is dealt with as informally as possible. And the child is spoken to in language suitable for the child to understand. So if you have a 17-year-old child, you will speak them one way. If you have a 12-year and 1 day child, then you speak to that child using different language. But it is supposed to be a non-threatening situation, a non-threatening scenario. It is aimed to try to understand why the child did what it did, try to get the child to realize that they committed an offense and to take responsibility for it, and for the child to then see the error of their ways. So I'm quite frankly, so I'm going to abandon the specific provisions of the legislation and speak generally, because one leads into the next in a way that the actual sections don't, and it just helps to tell a fuller picture. So consider the proceedings, sir. Child A slaps another child and mashes up their iPhone. The police get called, they pick up the child, realize the child is over 12, but under 18. They notify the parent, they notify a probation officer, and they try to understand what went on with relation to the child. They speak to the child, sir, in the presence of a probation officer or the person responsible for the child or an attorney at law. It must be noted, sir, similar to the child protection legislation, children who come into conflict with the law and who are dealt with under the child justice legislation are afforded legal representation at the instance of the state. So if you can't afford your own lawyer, the state will provide a lawyer to ensure that the child's interests are served. When they talk about the responsibilities of the lawyer, the first responsibility of the lawyer, sir, is to protect the interests of the child, right? And then it sets out the other responsibilities. So you're now in the police station and trying to find out what happened with this child. The police take the basic information. If they determine that the child is not a risk to the child or the child's or somebody else, they would generally release the child back into the family setting with a date set for the initial assessment and serve notice on the child or the parents. Similar to the child protection legislation, sir, this legislation seeks at all costs to preserve the integrity of the family. Every single option to get that child back home is afforded to the child. So at every stage in between, right, the child is given the option to go back home. Is only if home is unsuitable. It's only if the parental situation is unsuitable or the family environment is unsuitable that we look to place the child somewhere else or find alternative arrangements to deal with the child. Sir, it is deemed that this child must be subject to a further investigation, the initial assessment. The child is summoned to appear in front of the magistrate. When the child appears in front of the magistrate, as I said, all resources are there for the child to be properly represented and have the interests of the child represented. The magistrate, after the initial hearing, can decide to divert this case. It can decide that it is not in the best interest of anybody for this child to proceed to a trial, so let us try diversion. Sir, the diversion is meant to take the child out of the formal court proceedings. Where is a child to be considered for the purpose of the diversion, sir? It's probably useful to go through those. This is critical. The purpose of diversion is first and foremost to encourage the child to be accountable for the harm which he has caused, to meet the particular needs of the child, to promote the reintegration of the child into the family and the community. Please note, sir, it is not a by the way. It is a stated objective of diversion to promote the reintegration of the child into the family, and by the family, it means the family of the child, and into the community. Provide an opportunity to those affected by the harm caused by the child to express their views on how the harm has impacted them. Encourage the rendering to the victim of some symbolic benefit or by the delivery of some object as compensation for the harm caused by the child, restorative justice. To promote a reconciliation between the child and the person or community affected by the harm caused by the child from being subject to the criminal justice system, and to prevent the child from having a criminal record. Now, this is at the first stage. This kicks in at the initial inquiry. From the initial investigation, before the magistrate, these are the considerations. Get the child to repent, get the child to pay back, get the child to go home, get the child to bond back with his community, prevent the child from being stigmatized, and to prevent the child from having a criminal record. So for those who are concerned that we should not properly place the child in front of a judicial officer at the first instance, well, this person is a judicial officer. This person is a trained person in dealing with these matters and able to assess what is in the best interest of a child. Also, sir, it might not be expedient to convene a whole board. Children run into conflict with the law relatively often. To keep convening the board to deal with everyone is not practical. It is properly done by a magistrate who sits not in the role of a judicial officer, but in the role of an investigating officer trying to secure the best interest of the child at that point in time. Diversion. A child shall be considered for diversion where A, the child or his parent or an appropriate adult consent to the diversion and the diversion options. B, the child understands his right to remain silent and has not been unduly influenced to acknowledge responsibility for an alleged act or omission. So if the magistrate believes that the child is being forced to say, I did it, I am sorry, then they're actually not going to order diversion because that's not the proper consent of the child. And there's sufficient evidence to prosecute the child. So there has to be sufficient evidence to prosecute the child to order diversion, because if there was not sufficient evidence to prosecute the child, the magistrate would just dismiss the matter. So when you come in the initial investigation, sir, and there's not sufficient evidence, the magistrate at that point in time can say, there's nothing else to be done here. Waste of time. If the magistrate says, well, you know what, I do see the elements of a criminal act, I do see that this is something that should go to trial. However, I don't believe the best interest of the child will be served, or the best interest of the community will be served. I can't dismiss it because the elements are there. I, however, can send it in a different direction that secures a better outcome for the child and the community. Sir, levels of diversion option. Now, this one gave us some licks, because initially, the diversion was a straight diversion, but that then put the bar too high as to where should diversion occur. So it was deemed that we can set the bar a little bit lower, that more persons qualify, if we provide defined levels on which a court can operate. So those levels, sir, are: at the initial inquiry, a magistrate, in directing a diversion option in respect of a child, may direct a level 1, level 2, or level 3 diversion option. And in selecting the level that is appropriate for the child, the magistrate shall consider A, the age and developmental needs of the child; B, the background of the child; C, the educational level, cognitive ability, and the environmental circumstances of the child; D, the proportionality of the option recommended or selected to the circumstances of the child; and the nature of the offense and interest of the community or society. Please note, sir, that once again is a balancing act. While we are trying to secure the best interests of the child, it also is aware, the court is aware, and the legislation contemplates the fact that you may need to justify to the public why you're taking a specific course in relation to the child. Somebody might want to know, why this child look out my window and then going back home and nothing happened, right? So we have to balance the interests of the community as well. A level 1 diversion option includes an oral or written apology to a specified person or institution, so getting the child to acknowledge what it did was wrong; a formal caution in the prescribed form with or without conditions; placement under supervision and guidance for a period not exceeding 3 months; placement under reporting order, similar to probation, sir; the issue of a compulsory school attendance order; the issue of a positive peer association order in the prescribed manner in respect of a specified person in a specified place for a period not exceeding 3 months. This is novel. The peer association order allows the court to say, well, I actually only believe you found yourself in this position because you keep associating with the person from St. Lucie. If you did not associate with him, I meant any arbitrary person from St. Lucie. All right, let me leave out. I may find it funny, he may find it funny, but next time I see myself on social media. Right, so when a court, in looking at the circumstances as led in the initial assessment, determines this child's a follower. This child ended up there not because the child formed a criminal intent, not because the child meant to do harm, but because this child associated with these people. Chances are somewhere in there the mother would appear and say, I keep telling him not to go with this one here. I keep asking him if the child jump off a cliff, if he can jump off the cliff too. So that comes out. So the peer association order, the court will say to the child, look, you did wrong. I could actually make you go through a trial and possibly send you to a secure residential facility. But I give you a chance. But you cannot associate with these people, or you can't go to that particular place where you go and hang out on a Friday evening. Right? So that one, sir, is entirely novel. But it makes sense. A family time order, a good behavior order, the issue of order prohibiting a child from visiting, frequenting, or appearing in a specified place, a referral to counseling or therapy. So as a condition of your diversion, there can also be orders referring you to counseling and therapy, and you have to comply with these in order to remain diverted. Because if the diversion conditions are not met, so the court, understand the court is being influenced by the fact that you owned up to the offense, that you appear to be sorry, and you appear to want to do better. So if the court says to you, or even give you a chance to do better, and you choose to not obey the orders of the court, then you, even as a child, you must bear responsibility for your actions. Symbolic compensation to a specified person or institution, and a restitution of a specified object to a specified victim of an alleged offense where the object concerned may be returned or restored. So if in the same thing with the cell phone, you can't escape. If you cause damage, then before you exonerated or to come out at the good end of the whole process, then you have to make good for the damage that you've done. Summary here, sir, as well, is a fact that parents in certain circumstances can be made liable to pay the restoration or the fine where a fine is attached to a child as well. So that is the way down. So I'm not going to find it now. But effectively, we often say to ourselves, when you see a child doing foolishness, child breaking up windows on a bus or something, where the parents are, who can be responsible for that? If it is deemed that based on the entire circumstances of the offense, that the parent should have done better, or the parent knew the child used to be pelting rocks at people or pelting rocks at carers and didn't step in and correct that child, then the parent can be made to be held responsible for restoring or paying the fine. And when I say correct that child, there's a convenient point to point out as well, sir, that under this legislation, cruel, inhuman, and degrading punishment, that's the language that we now use. It was corrected from some other language before. And corporal punishment are not permitted in a secure residential facility. So for the avoidance of all doubt, a child in a secure residential facility shall not be subjected to corporal punishment or cruel, inhuman, or degrading punishment. I had this conversation with my father last night, who said to me, I hope he's not listening. He said to me, so you say parents can't beat the children? I said, Daddy, I did not say that. This governs what happens to the child in an institution. I also saw Her Excellency Faith Marshall Harris on TV last night talking about corporal punishment, and we need to get to a point where we explore other ways of disciplining children. That is not the subject for this debate. I'm saying that as it stands now, the law in relation to children, parents disciplining their children, is the law as it stands under the child protection legislation, which does not specifically address that, but which places you within the bounds of common sense, that if your discipline goes past what is reasonable and may cause permanent harm to a child or emotional scarring, then that tends to abuse and not discipline. But for the avoidance of doubt in the secure residential facility, children will not be corporally punished, not subjected to cruel, inhuman, or degrading punishment. So that's what I spoke to you about, sir, before was a level 1 diversion. A level 2 diversion pretty much includes the same things, but in those, the orders I referred to, sir, those are minor. Those orders were generally not to exceed 3 months in duration. For level 2, the orders can go up to 6 months and include a few more. Performance of some community service, the provision of some service of benefit to the victim, or payment of compensation to organization, charity or welfare organization for the benefit of the community where the victim can't be identified. So if you go and destroy what appears to be a derelict home and they can't find the owner, the court may actually say, you know what, we can't find the person, but the fact is you need to get back something, so go and wash buses like Transport Board or something in your summer. A level 3 diversion option includes referral to a program which does not exceed 6 months and which has a residential requirement that must not exceed 35 days in total and 21 consecutive days during the operation of the program. The performance of some service without remuneration for the benefit of the community, identified by a probation officer for a period not exceeding 160 hours, which should be completed within 12 months and no more than 35 hours per week. where the child is not attending formal schooling, compulsory attendance at a specified place for a specified vocational or educational purpose for a period not exceeding 6 months nor more than 35 hours per week, and referral to counseling. So the level 3 diversion should apply to a child who is the age of 14 years or older, where the offense that the child has committed, the relevant enactment imposes a sentence of detention. So, to explain that, the child justice legislation prescribes what happens to the child when the child comes into conflict with the law. You will be very hard-pressed to find a child being charged with an offense under the child justice legislation unless it relates to the behavior of the child while in a secure residential facility. So the child justice legislation does not, of itself, seek to impose criminal offenses on children, but deals with them once they've run afoul of the law. So for a level 3 diversion, which is the most serious diversion, if the offense that you've committed would normally result in a sentence of imprisonment, then you would have to do a level 3 diversion as opposed to one of the lesser ones. So the level 1 diversion is effectively what we would call a slap on the wrist. Is not an overly serious offense. The consequences were not that dire. The child is truly penitent, and the victim effectively agrees to be compensated. Level 1 diversion. Level 2 diversion, if it's a little bit more serious, right? You expand it, you know what? We would like to get a slap on the wrist, but a slap on the wrist would send the wrong message, but we still want to give you a break. That's a level 2. So your period of monitoring is 3 months, 6 months, and not 3 months. Level 3 diversion is where your offense is one, quite frankly, that you should actually be detained for, but they don't want to detain you for too long, and you're over 14. So the level 3s, sir, would affect children who are 14 years or over, because you also accept that once the child hits 14, the mental capacity to understand what the child is actually doing is significantly greater than a child under 14. Sir, the minimum standards applicable to diversion and diversion options. A diversion option shall, this is important, sir, promote the dignity and well-being of the child and the development of his sense of self-worth and ability to contribute to his community and society. Not be exploitative, harmful, or hazardous to the physical or mental health of a child. It shall be appropriate to the age and maturity of the child and not interfere with the schooling or education of the child. And the chief probation officer shall keep a register of all children who have been subjected to diversion. I saw an interesting thing, sir, the other day on YouTube, and people had their full say as to whether it was appropriate punishment for the child. I think the child had stolen something, and the parent found it in the child's pocket, and the parent put the child on the corner with a sign around the child's neck saying, "I'm a thief. I'm a thief." While it does not appear the parent beat the child, right? While it does not appear that the child was otherwise harmed, the fact is that exposed the child to ridicule, because everybody seeing that is going to call the child a thief. And if it was near the child's house, then all the child's friends would see that and call the child a thief. So our diversion options, sir, are meant to allow the child to recognize. It is important that the child recognizes what they did is wrong, because we want to cut that behavior in one. We don't want that behavior to perpetuate until the child becomes an adult and the consequences are more serious or more dire. So while we want to be as gentle with the child and promote the reintegration to family, reintegration to community, reintegration to the normal behavior and the normal well-being of the child, we also have to balance that we need to protect that child from whatever thought processes and whatever influences were there that led the child to run afoul of the law, to be in conflict with the law in the first place. And we also need to prevent that child from reoffending. You get the break when you're a child. You get so much of a break, sir, that any offense that you're convicted for as a child gets wiped out when you're 18. So you as a child start your majority with a clean slate, whatever it is. So under 12, we deem you not capable of committing a criminal offense. Between 12 years and 1 day and 18 years old, whatever offense you've committed, once you have served the time for it and done what it is that you're supposed to do, comply with whatever order, that offense is wiped out when you hit 18. We are allowing every single child in Barbados to start majority with a clean slate. What happens, you can clap for that. What happens, sir, with a child who commits an offense under 18 and it carries over to over 18? A child over 18 can't stay in a secure residential facility. In certain circumstances, I think there's some latitude there, sir, for 6 months to complete education. But generally, the child would have to complete the rest of its sentence in the government facility. But still, although you commit the offense as a child, so when you've served that sentence, then that is still wiped out. The other thing to note, sir, when we're looking at how it affects children and the record, understand you will only ever see the secure residential facility where no other avenue could be found to save you from that. So, sir, there will always be some who are hard-ears past the point of being hard-ears, who just will not learn, will not accept, will not be recalcitrant, will not be whatever. Those children are the ones that may see the inside the secure residential facility, or if the child needs to be protected from themselves. But outside of that, every avenue for diversion exists. Sir, if the trial has started, so we got past the initial assessment, and the magistrate says, you know what, this needs to go to trial. This needs to go to trial. And the trial starts. And somewhere in there, the court determines, you know what? Based on the full evidence that's being led, I'm actually prepared to give this child a chance. The court can still order diversion. Please note that with the initial assessment, I started by saying that it is not part of the criminal justice system per se, so it's not a trial. So if the initial assessment is done by the magistrate and it is deemed that the child should stand trial, all the evidence from the initial assessment is quashed. So that evidence is not relayed up. Any evidence heard in the trial is completely separate and must be led again. So the presiding officer must not be prejudiced by the open admissions, because you encourage in the initial assessment everybody to be really open. If the mother in the initial assessment says, this child used to get trouble all the time, I tired. The mother gets to vent that there. But if you then take as a deposition what the mother said in the initial assessment and relay that in the course of a trial, where the mother is effectively admitting this child hard, I couldn't stop the child, I warned the child about this, then it's going to prejudice the outcome of the case. So the evidence, any statements taken in relation to the initial assessment do not form part of the record for the trial going forward. So as I said, sir, going through the trial. So for example, the child broke in to Shafet and stole ice cream and snack boxes, right? So the initial assessment, the child didn't want to cooperate, the child didn't speak, the mother didn't say nothing. So all we have coming out of the initial assessment is that the child did break into Shafet, was caught on camera, stealing the stuff. And then the magistrate is going to say, all right, you know what? You want to help yourself, you got to go to trial. If it comes out in the trial that the child was hungry, ain't eat, the mother don't feed the child was being neglected, the court at that point in time can say, stop! While the child broke into Shafet, we can understand how it got there. And this is not a child who should actually be penalized and convicted. This is a child who is probably in need of the child protection services. So pause at any point in the trial. They can pause and refer the case to be continued under the child protection legislation, which, as I said, is geared at steering the child away from the formal criminal justice system and into a protective environment. I think, sir, it actually says somewhere in here, that's the problem when you jump around, sir. It says that a child should not be, hold on. Somewhere in this legislation, sir, it says that where a child commits an offense because the child was hungry or in need of shelter or care or whatnot, and it was related to that it would not be an offense. The child would not be found guilty of something like that. So even in this legislation, if you get to the point of a trial, we still start with the principal objectives to secure the rights of the child, to provide a fair hearing for the child, and to ensure the child is cared for and protected. So crossover, duplication almost of objectives. But once we see a way, or once there's an avenue available to divert that child from the formal proceedings, although they have started already, that remains an option available to the presiding officer to actually so divert the child, sir. Sir, if I start to wind down now, there are other things that this legislation deals with. We had, sir, to take a whole ton of heat in relation to the offense of wandering. Because of the attention on children and child justice a couple years ago, all of the child protection organizations, all of the stakeholders in child protection came down on the fact that wandering was still an offense. And there was many suggestions in there, sir, that this particular government was abusing children. There was a person who took a particular interest in me, and left to them, sir, I'll be facing some UN war crimes or something. I apparently abused children. I presided over the abuse of children. I hushed up things in relation to children. I skewed the investigation in relation to children. Sir, when we did the investigation into the government industrial school, I was hands off. We did a full commission of inquiry. Everybody said this would not lead to anything. This is just a way to just kick that can down the road. Nobody can read this, and the results will never be made public. Sir, all of the results of that were made public. The report was made public. The good, the bad, the ugly, the indifferent. No holes were barred. That was an exceedingly thorough report. And coming out of that report, sir, it led to a number of changes in relation to the way, I guess, the institution was run. It led to firming up of systems. It led to a decision to reevaluate the curriculum at the institution. It led to decisions in relation to proper qualifications of persons working at the institution. It led to a whole set of things, sir, and some of the things that it led to are reflected in this and in the tour that is currently going on with the officials overseas. I am happy to say, sir, there was no cover-up. There was no need to be any cover-up. If you put a pot on with a cover on, it can boil and boil and boil until the cover blows off. That's the reality. We're dealing with not, at the time, the 3 years of this government's tour since 2018. We were dealing with not my stewardship as the Minister of Home Affairs, nor the Honourable Member for St. James, nor stewardship, or even the stewardship of whoever went before. I think it was I don't want to guess at it, or whoever went before. Sir, the legislation dealing with children and the statutory offenses and the offense particularly of wandering, I do not think there's a soul in Barbados who's alive when that legislation was passed. I can't remember, I don't know if the clerk has the exact date of it, but it was back in the early 1900s. 1927, or maybe a couple of people. That was meant to control black people. The offense of wandering was meant to curb young black women from being on the street. You had to give an explanation as to where you were. I actually asked somebody to check for me, to research and to see whether any Caucasian person was ever charged with wandering, and I was unable to find a case. And quite frankly, with Barbados being the proportions that it exists, once they had 10 cases, then one should have been white. Once they had 100, then 10 should have been white. In the history of that offense, I could not find a record of one Caucasian person being charged with or being convicted of wandering. And why was that unfair? In addition to the racial inequity, the legislation was offensive because there was a mandatory minimum sentence. If you remember, sir, the case of Boyce and Joseph and those, what the court found offensive was not that there was a death sentence, but that there was a mandatory death sentence. So it is almost trite law now that any mandatory minimum sentence that takes away the discretion of the court is likely to be found unconstitutional. So what led to the revocation of the mandatory death sentence was the fact that once found guilty of murder, there was no option on the court. The court had to pronounce the sentence of death, no discretion. It was the same thing, sir, in relation to the charge of wandering. When a young woman, and this applied only to women, it applied only to girls. When a young girl was found guilty of wandering, the mandatory minimum sentence was 3 years. So if you were found guilty of wandering, it wasn't that it was slight wandering, it was your first offense that, let me get you 6 months. Or, well, you're guilty of wandering, and here, let me put you to talk to a psychiatrist or a psychologist or enter into a program. If you were found guilty of wandering, your sentence was 3 years. That was as offensive as it comes. And when, as I said, when the pot hit boil, all fingers are pointing in the direction of the person who unfortunately happened to be the minister at the point in time, which was me. Once again, I thank my board for ably supporting me in that period. But the reality is, that went through every single government, every single Minister of Home Affairs, every single parliament that sat in Barbados from the 1920s. And people express outrage. People express dissatisfaction, but nobody saw fit to sit down and change it. Well, we have changed that in this legislation. And understand something, sir. The court gazumped us slightly. A court found that the sentence of wandering was unconstitutional, the offense of wandering was unconstitutional. But please note that by the time the court actually ruled that, this legislation was in draft and was being circulated to stakeholders for final advice for the government to bring it in. So quite often, sir, you will see that a court decides something is unconstitutional and then you get an appeal from the government. And in many constitutional matters, sir, the appeals go as far as the CCJ. You realize, sir, that when the court said that this offense is unconstitutional, there was not a word. The AG came out and said, I agree. the government will not be appealing. That decision came out the morning. By the afternoon, the Attorney General, in his first comment on it, said the government will not be appealing that decision because we had already decided to change it. The court just got there one step before us. But the fact is, we are about legislative reform. This government is about legislative reform. This government is about modernizing our legislation. We can't get all one time. We have a very active law reform committee. There's a criminal justice committee as well. We have very active law reform arms of this present administration that are looking and trying to bring our legislation and legislative agenda kicking and screaming in line with current realities and current norms. In many instances, sir, if we methodically go, we will never catch up. So what happens is persons raise particular issues of concern for them, and then we look at those that say, yeah, this needs to be changed, and we try to deal with that one as a matter of urgency. Based on what was going on, sir, we decided to let us go holistic. Let us just go the whole route, sir, and reform the matters in relation to child justice and child protection. And that has brought us to where we are now with what I consider to be the most comprehensive. It is definitely the most modern suite of child protection or child-related legislation in the world. We sought advice from as far as field as we could in dealing with both the child protection and the child justice legislation, sir. We considered the model legislation out of the UK, Canada, New Zealand, Australia, all of the known places that have well-established family law jurisprudence and child protection jurisprudence. And we have managed to put before the Parliament what we considered to be the best legislation we could come up with. But then we had the built-in additional extra. Having brought it before Parliament, the decision was always made by the Cabinet, sir, that we would introduce the two pieces of legislation to Parliament and then we refer to select committee. So in bringing them here, we knew that the Honourable Member of St. Michael South would speak once and then it would be referred to select committee. We knew that I would speak once, it would be referred to select committee. My address today is way more detailed than it was the first time I spoke because, quite frankly, it didn't make any sense going that far when I knew we were throwing it open to everybody to comment, so which is why I'm going into a little bit more detail now than I did back then. But we managed to put the most comprehensive legislation we could before the select committee and then allow Barbadians and the interest groups to have the final say to provide what is truly a nationally inputted piece of legislation. So, sir, for certain persons to try now to thump their chests and steal the joy of the people and to say that their agitation, their particular agitation, is what led to it going to the select committee and is only after the intervention by those who he represents was it properly consulted and properly structured and properly framed, is almost as offensive, sir, as the offense of wondering. I wonder what he was thinking and how he managed to wander into such a misapprehension of what actually occurred. But I wonder no more because in short order, we will produce a piece of legislation of some wonder of which we can all be proud. Sir, I don't think it is necessary. The rest of what I had intended to speak to you about, sir, are things like grievance procedures, postpone or suspension of sentences, and that sort of thing. But let me just say, to wrap up those, the bulk of that I spoke about before, and the provisions dealing with suspension of sentences are all skewed in favor of the child. There's a provision to suspend sentences or postpone sentencing to give the child an option to do the right thing and thus not have a criminal conviction or not have to go through any more of the formal processes. Sir, I am satisfied that at every single turn, we look to try to circumvent the tentacles of the child justice legislation and to instead refer the children to the warm embrace of the child protection legislation. Here I am portraying myself as a bad guy and the Honourable Member for St. Michael South as a good guy, but is good cop, bad cop, but we're both cops. Yes, sir, we will. Oh, last thing. There's provision as well, sir, for the curtailment of a sentence, similar to parole. Once a child has served 2/3 of his sentence, then an application can be made by the appropriate adult, by the director of the secure residential facility, and the minister, on consultation with the appropriate persons, can decide to release the child early. So once 2/3 of the sentence have been passed, then the child comes up for consideration for early release. So that's yet another thing in favor of the child, to build it out so the child does not have to be there longer than it has to be. At every step of the way, the appropriate adult or the parents are consulted and notified. The only real offenses created by this legislation, sir, relate to, and by that means, I mean criminal offenses. There were some offenses in there, but in keeping with the government's policy to do civil offenses as opposed to criminal offenses, the ones that would have criminalized other persons under this legislation, we've changed to being civil offenses, and that will come in the amendment when we do the second reading. And, sorry, that will come in the amendment when we go to committee. And we are trying at all costs to do what is right by the children. The only offenses that are criminalizing here are the failure to keep the reports in relation to the child, which those duty bearers must do. And the other one, sir, is in relation to publicizing information about the child in a way derogatory, negative to the child. Proceedings related to children are supposed to be heard in camera. In camera means that it's supposed to be heard in the absence of anybody who does not have a specific reason to be in the court at that specific point in time. We are a bit lax in that now. As it stands now, officers of the court have a right to be in the court. So if you're a lawyer in the court and proceedings come up in relation to a child, then you are not asked to leave the court, but everybody else has to go outside because you're deemed to be an officer of the court. I actually think this puts a more strenuous burden on it. And the in-camera provisions apply. Where somebody publishes information about the child or the offense, sir, and it includes social media. So when they publish to a publication that effectively defeats the whole intention of this to preserve the dignity and rights of the child and whatnot, that person, sir, is guilty of a criminal offense. So that's where the criminal aspect comes in relation to this. That person is guilty of a criminal offense and can be prosecuted as such, but it makes sense. I believe if the whole of the legislation has been worded, geared, aimed at ensuring the dignity of the child and the ability of the child to reintegrate and protecting the privacy of the child and its ability to join back its family, and some malicious person decides to go and skin out the child's business on social media or through a reckless publication, then that person should actually be charged with a criminal offense because I believe it is negligent and it is criminal. We're not going to bow to that one at all. So, having said all of those things, sir, it is my great pleasure to stand behind this piece of legislation. I think an honourable member had been quoted as being referred to as being the parent of a piece of legislation in a widely publicized back and forth between her and the honourable member for Christchurch South, and she put him entirely in his place. That was his association, not necessarily hers. I will say that, so I claim this one. I'm proud to claim it. I claim it on behalf of all who work to see it done. I claim it on behalf of the board of the Government Industrial School who's here with me now. I claim it on behalf of the probation department who is here. Sir, I claim it on behalf of all of the stakeholders. I claim it on behalf of the child advocates. I claim it on behalf of the Ministry of People Empowerment and Elder Care. I claim it on behalf of the Minister. I claim it on behalf of the Child Care Board. I claim it on behalf of all who will have cause to utilize this. Because normally when we amend legislation, and we amend legislation dealing with criminal matters, we always invariably amend it to be more rigid, more tight, less loopholes, trying to catch the bad guys. I am satisfied that in this, we have done the opposite. We have delivered a piece of legislation that adequately serves its purpose, bearing in mind its stated objectives, that deals with children and their families in a preventative, restorative way, while preserving their rights and dignities. And I believe that this is a signal piece of legislation that has forever changed the landscape in Barbados, and combined with the child protection legislation, that these two pieces of legislation has put beyond all doubt this government's position in relation to its children, in relation to their protection, in relation to its perspective on families, and just generally in relation to doing the right thing at the right time. I thank you, sir.
Honourable Member for St. Michael South.
Thank you very much, Mr. Speaker, sir. I want to begin by commending the Honourable Member who just spoke, who I believe has given an excellent speech and a fantastic representation, sir, of the Child Justice Bill, also of the Child Protection Bill, given his intimate knowledge of both pieces of legislation. Like I did on the Child Protection Bill, sir, I also feel that I must also thank the committee chaired by the Honourable Member for St. George North and the work that she and her committee would have done to get us to this place, sir. It was not an easy task, but it was done very well, sir, and it being the first set of meetings, so I want to commend the chair. I also want to commend those who had the arduous task of putting together this report. It is a very well-written report that allows the public to take a peek at it, sir, and to see that we went to do serious business. So, sir, I think that would be your staff, and I commend your staff for the work that they would have done to help us go this. I also want to again thank those who helped. The Honourable Minister spoke to all of those. So we shared many of the same persons during the course of this process. And I again want to thank all of those persons, sir, who helped us out. But I feel specifically inclined again to thank, permit me to say, Faith Marshall Harris, whose support to myself personally and to the ministry was invaluable. I must tell you, sir, there were times during the first iteration of this bill when I asked myself, where are these things coming from? And her personal support to me was very useful, sir, and I thank her for being a friend and also for her mentorship in many ways on child protection issues. Mr. Speaker, sir, I don't intend to be very long, or notwithstanding the fact that the Honourable Member for St. Peter seems to think that I will be, given that I made so much notes. But I was taking notes because I thought the Honourable Member for Christchurch East was making a sterling presentation. So when I was a young public servant, my first real job, I had a job stuffing pillows once at 10 cents a pillow. So you have to stuff 200 pillows to get $20. That was not easy. But that was my first real job, and sweeping the factory. They asked me for my CXCs when I went for my interview. I thought I was getting a clerical job, and the guy presented me with a broom. But Mr. Speaker, sir, I want to begin this way, sir, because I think this is a regular bill for regular people. When I was, my first real job as a public servant, I was at the VAT office, and the then director, again, permit me, sir, Mr. Moore, anointed me VAT man number 2 and himself number 1, and asked me to join him on this PR campaign. One of the first things we did was an interview with this TV program then called By George. I don't know if you all remember it. And the first question that was asked of me, having presented the VAT bill, because VAT was new. This is now 1997, I'm very young, and VAT was brand new. And his first question to me was, what are the penalties in this act for dealing with people who don't pay their VAT? And I staggered and stumbled all over the question. Though I knew the answer, it caught me off guard. But my point was, for the most part, people like to start at the end. They like to start on penalties. You know, you have an interview with a newspaper, they ask you, what are the penalties? How are you going to punish, and so on. The Child Justice Bill, sir, must not be seen as in the same regard that the guy on the By George program saw the VAT bill. We must not begin at the end. In my mind, sir, we must not repeat that error. And the question that comes to my mind as I reflect on this bill takes me to the book of Amos. The Honourable Member for St. Peter again. I'm spending too much time with him, my good Christian friend who bringing me to a better Christian understanding. But he says, sir, in that book, and Martin Luther King made it famous, he said, let justice roll down like waters and righteousness like a mighty stream. Let justice roll down like waters, sir. So I ask myself, where does justice begin and where does justice end? And the idea that justice must not only be done, but that it must be seen to be done, causes me to ponder, sir, on our entire system. The question for me then, obviously, sir, is in trying to understand justice, are we being of great justice, sir, to our young people? Are we doing the best that we can do for our young people, sir? And I want to take this opportunity not to give a long policy brief, sir. I believe I did that last week. But I feel, sir, that I want to just share some of my personal experience in relation to the topic that is before us. And I also, sir, would use this opportunity not only to talk about the justice system, but what I believe is the system of justice that we must reflect upon. And to ponder on, sir, because unless we get everything right in relation to this matter, unless we tackle this issue at the core, we could have a great justice system, sir, that is an injustice to the people who need it most. If we, sir, were to begin at the end. I think, sir, that my presence in this parliament is an anomaly in many ways. Not because I was born poor, sir, most of us were. But in the pain where I grew up, sir, I think we came to normalize things that are really not normal. When I was a boy, sir, I recall getting myself into trouble at primary school, skipping school, being told on by my bigger brother, who used to skip school. I got myself suspended from secondary school. I got myself suspended from community college. I, sir, grew up in an environment where those who mentored me told me, the Honourable Member for St. Lucie, sir, please ask him to leave me alone. But sir, I grew up in an environment, sir, where I was told that if a man or somebody do you something, you're doing something 1,000 times worse. That's what we were taught. And regular boys, sir, regular boys, playing football, playing cricket, playing road tennis, sir, you know, experiencing girls for the first time innocently. Having a rather innocent experience at 12 and 13 and 14, sir, my friends and myself, I must confess, capable of the greatest violence. And it came to me then that those of us who are born in lower socioeconomic communities are not born prone to violence, prone to crime, unless, of course, your belief is that of the behavioral theorists who argue that you're born a certain way. This moral underclass debate that poor people are a moral underclass, and that regardless of where you put them, because they're poor, it's in their genes. I don't believe that as a nonsense. I believe that the socialization is very important, sir. But these regular boys, capable of immense violence. And the thing that I found reflecting interesting, sir, is that as you try now to understand blocks, I mean, I'm saying this to you, I keep saying this to you, but I look forward to the day when you're not the speaker of this house, sir, so that perhaps once or twice you get to speak as you should be allowed to speak, sir, on these social issues. But, sir, I say this when I watch these regular young men, bright as they are, but capable of great violence. Taught as we were to be quick to anger, the tools that we were given to help us survive a childhood in the pain, as they are the same tools that are given to many of us who grew up in other areas, like some parts of the community I now have the privilege to represent, areas that you have the privilege to represent. The tools that were given to us to negotiate day-to-day existence, that we came to honor and to cherish, sir, are the tools that often we have to put down to be able to progress in society. But nobody teaches us that. Because our mentors and those who we look up to, they only know the other way. I went to the Wilkie Cumberbatch Primary School, sir, at a time when we did 11 plus. I passed for the St. Michael's School. I think in that class, 17 persons passed for Harrison College, a good few for QC, several for Combermere. Wilkie Cumberbatch is located in the heart of the Pine. And I give this example because it is not that the children from these areas are less intelligent. In many cases, I would submit, sir, they're more intelligent. Because you have to be really intelligent to be able to get by the 11 plus, and I think the time has come for us to really talk about this exam. Because I don't know, putting so much pressure on an 11-year-old child for one exam to determine the rest of their life makes sense to me. But sir, we really have to talk about this 11 plus examination. I think the time has come. But I watched my friends and myself, sir, all of us passing for good schools. That's the truth. Most of my friends kicked out by third form. Why? Because the tools that we were given to negotiate day-to-day life in the Pine and at Wilkie Cumberbatch Primary School too, because the truth is at Wilkie, all of us were the same. All my friends were from the Pine. And so what carried on in our constituency, community, carried on in the school. Somebody says something to you, you treat them 1,000 times worse. They say something bad, you say something worse. They come in your face, you do them something more cruel. That's just the way it was. But those tools that you take on now to secondary school, where you come into contact with different persons, sir. For the first time in my life, sir, at St. Michael's School, I found that there were children, you say something to them and they don't get vexed. But this was novelty. Because you say something to everybody where you grew up, they vex. And, you know, a fight could break out just like that. That's the truth. And for those of us, sir, I did not grow up sheltered for 1 second. For a second. I had a regular life, sir. I spent a lot of my time doing regular things. I want to thank, sir, permit me to say, Hamilton Lashley and Rodney Grant and those kind of guys who put programs in place to help recognize people and help to break this cycle, sir. But those of my friends who went to those schools, sir, many of them kicked out of school in 3rd, 4th, 5th form. Again, sir, this is something that we have to look at, this superannuation business, where a child who does not necessarily fit into what we consider to be the model child in a school system that is supposed to deal with all kinds of children, sir, cannot get the benefit of a full education because they behave differently from what the school anticipates, but they behave in the way that they are taught, sir. And if you were to remind yourself of the sociology you want start, sir, you would remember, sir, that in sociology they speak of the hidden curriculum. The functionalists argue that it's necessary, that the hidden curriculum passes on values and norms and ways to behave, and it helps to shape you. While if you have more of a Marxist orientation, you accept that the hidden curriculum, sir, perpetuates systems of inequalities and inequities, affects justice, because in that system, the system built into the hidden curriculum It is not meant to favor children born into lower socioeconomic communities. So I believe that both are true. That on the one hand, you have a system as a functionalist that teaches you norms and values and certain things. But on the other hand, sir, if you don't speak the language of the school teacher, if you don't dress at the school teacher dresses, if you don't move a certain way, your parents can't afford lessons so you could come first in class. You know, I used to tell myself, sir, at one point at St. Michael's in first form and second form, these children real smart. Like, how they so far ahead? Not knowing that everybody in the classroom getting lessons on Wednesdays and Saturdays. The children of poor people, sir, can't say that they're going to lessons. You know, when I used to teach sociology and social policy at the university, I had a class, sir, and we were talking about poverty. And one of my students got so upset when I said children of poor people. I just remembered it. She said, how could you call them children of poor people? It's because they are. I said, do you have a problem when I say rich people? She said, no. Do you have a problem discussing children of rich people? No. Because they're children of rich people, but they're children of poor people too. And that we have to have these hard conversations, sir, because justice, I believe, sir, the way that we have to think about justice, sir, is deeply embedded in our social structures and our social institutions. And that if we're going to tackle this thing properly, we have to tackle it, sir, from all of its various angles, sir. So we have to start at the beginning or the many beginnings. So that as we enter the system, sir, those of us who come from different backgrounds, sir, we enter it in a way that is fair, sir. Sir, I am convinced that to solve the problems, sir, for children who face the justice system, sir, we have to look at this thing from various angles. Sir, I've already spoken about education. I think our education system needs checking. I'm very happy to see that we are in the process of reform, sir, because that reform is necessary. And while people get and they say all kinds of things, a manner of evil about the member for St. Philip West, sir, the work that the member for St. Philip West is doing will serve Barbados for many, many years to come. So I also think about it in relation to the work that we're doing for sports. You know, I knew a young man who boasts that he once ran against Obadeli and beat him when he was a boy, 9, 10. But he hadn't gone on to the Olympics. What was the difference in their life circumstances? I know people, sir, who grew up as you do, as most of us do. If you look for the best footballers, you're looking for those best footballers where in these same areas. In the Pine, Gore Hill, Silver Hill, Haynesville, Silver Sands, to a certain extent. But you're looking in Bridensill, sir, Notre Dame and Wales, sir, down in the Bayland and Carrington Village. Because there is something about skills, sir, that is just natural. But somewhere along the line, there's just not the support in place to allow us to translate this natural skill to something more. So that's why we should commend the member for St. John and the work that he is doing. Because we have to put in place systems, sir, to allow our young people to get the maximum benefit of the Barbadian experience. This Barbadian experience, sir, that we talk of must not be the exclusive preserve of a privileged few. The Barbadian experience, sir, must be for everyone. Everyone, sir, regardless of the circumstances of their birth, sir. When I think about the Child Justice Bill, sir, I know normally when you think about justice, the question that comes to mind is what? What did he do? What did he do? When did he do it? How will he be punished, sir? But the question that comes to my mind is a question of why. Why, sir? Why are we here? Why are so many of our young people before the justice system? Why, sir? And why are you tainted at 12 and 13 for the rest of your life, sir, for things that really and truly should not have been your fault? The honourable member spoke of the former crime for wandering, which we took off the books. And I think that is one of the most important things, sir. This country will owe him a debt of gratitude for years to come because that was an evil and it was wrong, wrong, wrong. I want to thank the member for Christchurch East for fixing that. Barbadian children now will not be criminalized for that. I said last week when I spoke, many people are not running from something, not running to something, they're running from something. But at the end of the day, sir, why? Why can't our footballers who are so skilled in Bredinsill and so on go on to achieve the greatest glory? Why? Sir, again, I think the answer lies in the social system. I've also spent a lot of time, sir, trying to understand the family. You know, the reason that I studied social policy was because when I did my first master's, sir, when I did social policy, my mind was set on doing a business master's, you know, try to make some money and get out this struggle. There was a man, sir, who died brutally. He was a friend of mine, but he died brutally. I mean, you know, you live by the sword, you die by it. So I'm making no excuses for him, but he died brutally. I remember he would always see me when I was going to university, and he would say, Kurt, you gotta get out this struggle. But he would always add, you have to come back and help people get out too. So when I was younger, I remember speaking to Hamilton Lashley, sir, again, and Rodney Grant, and we were talking about what is it that we could do to help people get out. The struggle, because the struggle is a mindset thing. How do we help people get past this thing? You know, some people feel that there is some dishonor in doing well in school. There is some dishonor, sir, in being able to hold down a proper job. You feel that you betrayed where you're from. But the real betrayal is in not doing those things. And how do we teach that to our young people, sir? I remember before we came into office, when we were canvassing, the Prime Minister spoke to some young men in my constituency. And we said, if you go and do this training program, when we get into office, we promise we will get you all some jobs. I couldn't convince them then to do this training program at all. Even though sometimes it is a struggle, sometimes to convince persons to do these programs. And I do not think it is only because these men are lazy. I think because of our sociological underpinnings and how we've been taught and raised, that there is something disloyal, some betrayal to who you are as a person, as a ghetto youth. Then you try to do these things. And I, sir, feel that as we build our social programming, we have to honor what it is we know about those persons, sir. So we can take them from one place to another. At the end of the day, sir, if we are able to do all of these things, consider what people have been through as we build our social policies, as we build our social programs, sir. Because the conversation that we're going to have about economic prosperity, sir, must be a conversation about social programming too. And if we're going to talk about prosperity for all, sir, it must include children who are before the justice system. It must include children who are before the justice system. I know, sir, growing up again as I did, sir, my mother being a conductress would be, I hope she's not listening, Lord. But my mother, sir, used to double a lot. Conductresses would know what doubling was. You leave home at 3 in the morning to do the early shift. When you finish at 2, you got to double, so you get home about 9. You know how it goes. So from morning to night, from darkness to darkness, sometimes my mother would not be home. It's not easy raising 8 children on a single income, especially when that income is a small income. And while she was out pursuing economic prosperity and being able to pay the bills, really, it meant that most of us were home by ourselves for many times during the course of the day. And, you know, in nature, as it is in social structures, something would either rise or fall to fill its place because nature abhors a vacuum. And what you saw was that in many cases, people, often of nefarious intent, could slip in, sir, and start raising your children. People on the block, sir, you might find men in the community who have more money than others, sir, talking to your girl children. These things, sir, because there is a space, and people fill that space, sir. You ask yourself, sir, what do we have to do now to be able to address that? That idea that as you pursue what is best for your children, sir, somebody or something is slipping in to fill that space. We saw it. You say oftentimes, sir, in the society that we live. And now, The question is no longer who it is, because there used to be a 10-year child had to go outside to come into contact with something that was pernicious. But now your child stays at home on their computer, on their phone, spend the entire day on the internet, sir, coming into contact with information that is too adult, with scenes that are perhaps too graphic, and they themselves now, sir, having the same experience as those who would have gone outside. Our social systems have not evolved, I think, our institutions have not evolved to address the way the society has changed. In this child justice bill, sir, that the Honourable Member for Christchurch East has brought, there is a nexus between his bill and my bill, and the child protection bill. In the child protection bill, sir, and I think we have to make this explanation clear because I saw somebody post something on social media. In the child justice bill, there is a secure residential facility. In the child protection bill, there is a secure treatment facility. These are two different facilities. In the child protection bill, the secure treatment facility imagines a child who is abused, perhaps, who comes into care, and who needs extra attention. In the child justice bill, the secure residential facility, for the most part, is for a child who would have committed what would be an offense, a criminal offense. So that there might be a case for diversion, so that you move the child, recognizing that that child needed extra attention, into the child protection bill, into child care, into child protection, but that these are two different institutions. And while I'm on it, sir, if the Honourable Member for St. Michael South Central were here, while I am on it, sir, let me just say, I have no love for institutions. And I know that the Honourable Member for St. Michael South Central, herself a development specialist, also has no love for institutions. But the society that we live in makes it necessary. I now have to get more institutions for the elderly, more institutions for persons with disabilities, and of course, regrettably, sir, this secure residential facility and secure treatment facility, because that is the way the society has evolved. And therefore, sir, the nexus between our two bills, sir, allows us to say that when we combine the work of the Honourable Member for Christchurch East and the work that my ministry is doing, we offer the most holistic package for children ever in the history of Barbados, sir. We will be able to treat the children, sir, in all of their various components. But I strongly believe, sir, that prevention is better than cure. And that the way we must start our social justice conversation is not a conversation about the justice system. It's really a conversation about family. It is a conversation about community. It's a conversation about education, those things. If we have that conversation, sir, and we get it right, we reduce the number of children who perhaps come into contact with the justice system. Again, sir, as a boy, I remember there was a man, on every block, sir, there's a prophet, there's a block philosopher. Every block. On my block philosopher, sir, he used to always say, when the police came, we would run. It was just the way it was. The police come in, you can run. And as a boy, so I never smoked, or nothing. But the police come in, I can run. And I remember once the block philosopher was asking, I'm not calling his name, he would say, the police cars say to serve and to protect, but why are we running? Because they come to make us serve time protecting other people. And, sir, that is funny in a way, but you gotta ask yourself what's really happening there. In the city, there used to be a community near, I think the area where we were fixing Murphy's Pass, there used to be a community policeman. I don't know if he's still there on Memphis City, but he was a community police officer of great distinction. And all the people in the community knew him very well. And I think, sir, again, that is the kind of policing that we also need. A kind of community policing, sir, where you go in and you know the persons who live in the community, you know their children, you know the things that they care about, sir, and that you offer a holistic intervention. Because at the end of the day, sir, we don't want more and more children before the justice system. So, sir, I will close by saying, sir, that in my mind, the length of time sometimes these cases take, though, is too long. You know, you commit an offense, sir, and at a certain age, sir, sometimes these things take too long. I know, sir, in the current bill, I think in the current law, the minimum time that you stay in a juvenile facility is supposed to be 3 years. The current one, not the new one. And in the child protection bill, sir, you are allowed a maximum of 3 years. So it's a reversal. You get to come in, sir, and you get to spend, and you get to be treated, and you get the proper attention and the things that you need, sir. But some of these things take too long. We saw it, sir, with women, young girls who are abused, sir. You just saw a case, sir, of a child who perhaps was abused. The case finally called and came to a conclusion when the person was 24 or 25. That's an injustice, sir. You have a case where a girl is abused at 7 or 8, and by the time she presents to court, finally, she's 22, maybe, loaded with tattoos, has a bad attitude according to the court, too many children. So what the judges see, the magistrate see, the public sees, the jury sees, sir, it's not the child who was abused. What they see, sir, is a person who they think is a rebel, a deviant, and what they cast judgment on, sir, is not the child who was abused and not the sick pervert who abused the child, but they cast judgment on the woman, sir, who presents to the court many, many years after the first incident, sir. That is an injustice. We have to get that right, sir. We have to get it right. Sir, for most of us who would have, in my case, I was having this conversation with the Honourable Member for Christchurch West Central just the other day.
Honourable Member, you are...
1 second.
No, I'm just asking the question. You are aware of the constraints of your intervention?
Yes, sir.
I was just checking.
Yes, sir.
No,
but I also know, sir, that you alone can determine time in this place.
That is why I made it known to you.
That is why, sir, I hold you in such high regard. As I close, sir, I was saying to the Honourable Member, the Minister of Environment, just the other day, we were having a conversation, I think we were in Cabinet. And we were talking about the circumstances of our own families, sir. You know, there are some cases where a whole family gets out of poverty. You get a mother has 4 sons, all 4 go on to do great. Maybe one gives trouble, sir. I am the anomaly in my household. And I know that there has to be something, sir, that we have to do to break this system. There has to be, sir. I do not know if I will get to finish it, sir, but there has to be something. If not, we will lose a whole generation, sir. Someone said to me the other day, you can't choose your family, you choose your friends. If I could choose my family, I would choose the same family. I love my family too much. But I also know, sir, the social pressures that come to bear on these individuals and families in certain areas, sir, is too great, sir. That is why when I think about the Child Justice Bill, as I close, sir, I welcome all the many interventions, sir. I welcome all the many interventions that the Honourable Minister responsible, sir, the member for Christchurch East, has ensured are in this bill, sir, because in my mind, this is not a bill only about what did they do. It is a bill about why did they do it, sir, with solutions. I thank you, sir.
Honourable Member for City of Bridgetown.
Thank you very much, Mr. Speaker. I rise at this time, Mr. Speaker, to support add my support to this debate. Not only because I'm a member of this side, Mr. Speaker, or a member of the tribe, but Mr. Speaker, the truth is that this particular report, which I had the privilege to sit on the committee, is one that represents for me this administration, not just talking the talk, sir, but walking the walk. Mr. Speaker, sir, I sat on the committee chaired by the Honourable Member for St. George North, and I must say she did a sterling job in getting us through clause by clause, and in this case, bill by bill. And I also want to take this opportunity as I rise to make my short contribution to give credit to the Chief Parliamentary Counsel as well. Because as we took contributions from the public, all of the confusion, all of the misleading statements, all of the untruths, written or verbal contributions, was dealt so aptly and succinctly by the Chief Parliamentary Counsel to ensure that by the time this Parliament has the delivery of this report, that all of the matters have been sorted. And if you listen in the atmosphere where this bill is now being discussed, not that you may not find a detractor or two, or a critic or two, but listen to the tone and take the temperature, and you will realize that there is a massive difference between when there was a misunderstanding and when these things were cleared up by that particular select committee, both on child protection and child justice, sir. So for me, the particular issues raised in these bills, sir, speak to things that I've been dealing with throughout my career in social work and working with at-risk youth in particular, sir. Things that I've been calling for as a youth advocate, as someone working in the field of youth. They're covered in this bill. I have said to the Honourable Member for Christchurch East on many occasions, the bill is the closest thing to perfection on my reflection of 25 years working with at-risk youth. And I can speak about the specific sections so that you just don't take it as generalized rhetoric, but that you can see specifically where I believe that as an administration we got out to be proud with this particular bill, with the result of this particular report, because as I said, it demonstrates us not just talking the talk about fairness, justice, and good governance, but it demonstrates us being able to walk that talk. It speaks to the maturing of a society. I remember coming up and things of abuse, we saw many of the aspects of abuse very differently. Beating of children was a rite of passage. Incest and sexual abuse was swept under the carpet to the point you can walk on the carpet too lumpy, you will fall down, sir. But what this particular legislation is doing, it is introducing into the public atmosphere the discussion, the debate, the opening for public awareness and education, led by other agencies like UNICEF and others, to ensure that we can turn the tide of a culture. And how do you change a culture? You have to change behavior. And how do you change behavior? It must start with that public awareness and engagement with people. And I think that we are on the right path where that is concerned. Mr. Speaker, sir, I have to commend the House and my colleagues in the debate in child protection bill started and led by the Honourable Member for St. Michael South and continued by every single member. I am definitely a proud member of this administration as I reflected on every member's contribution and how they made an embattled plea to ensure that the children of this country is cared, protected, and served with justice in this country. It's an excellent job by the members of the administration. No two ways about it whatsoever, sir. Sir, moving on, one of the things I want to underscore, because the debate quality was so high, there are many things I don't wish to repeat, but there are certain things that I want to reiterate, underscore, and put in bold. When we talk about statistics of child abuse, when we talk about statistics of crime among youth, we have to understand that these are reported statistics, and most times when you have reported statistics, you're barely touching the tip of the iceberg, because many of these things are not reported. And therefore, you have to use it as a gauge of how to treat to the issue, understanding that there's a lot of ice below the tip of the iceberg. And I think that that is one of the things, because many members touch on the statistics, reported cases. These are just the reported cases. Bear that in mind. Mr. Speaker, sir, I want to turn now to my contribution. As I said, I am not like others. When I say I can be short, because I know, especially when you're just before lunch too, you have to take that into consideration. So, Mr. Speaker, sir, I can move on swiftly. And I'm going to talk about the walk. How are we walking the walk? The walk, for me, sir, is demonstrated in the facilities that we spoke about. These facilities are critical, because these facilities close the loop of justice, close the loop of care and protection. And what it is I'm talking about. Sir, I am not afraid or ashamed to stand here and say, even at the age of 10 in class 4, the head teacher of my school called the Dawes van for me and my friends. Why? Because I was not the best behaved person at school. But even as I reflected on those times, I remember there was no consideration of what was going on with you at home. There was no idea of fairness. There was no idea of psychological assessment, whether it be now we talk about ADHD and ADD. It was just your hard ears. You can feel. Hard ears, you went here, or you can feel. So there was no assessments. There was bamboo, belt, tambourine rod, bull pistol. That is how we treated to these issues. First and foremost, beginning and end, period and full stop. But what you're seeing is a maturing of a society that understands that when you know better, you must do better. And because we know that when a child is acting out, or when a child is running from a home, it is not just simply put that the child hard ears, wicked and evil, belligerent, and you can beat it out of them. This is not meat that you're tenderizing, sir. These are human lives. And therefore, it is important for me as I look through these bills and as I went through the process, clause by clause, line by line, that I see a demonstration of the fact that we understand where it is we are going. Now, we had facilities before. What are different about these facilities? These facilities are not about just punishment. These facilities speak to understanding the need for therapy. Being in the role that I am in now in crime prevention, sir, and previous to that, there are certain things that I understood clearly in the public debate as it related to child violence and care and protection. And that is, a lot of the time, we like to treat to the crime, which is really a symptom. We like to curse the darkness instead of lighting the candle. We like to look at the drug use and the stabbing and the violence and not peel back the onion and ask the why. How come? What led to this? As a child is born, he comes into the world, he is like a blank piece of paper. What and who writes on that paper determines, sir, the fruit of the tree. And if we have a bad fruit of a bad tree, the reality is you cannot destroy the tree by looking at the fruit. You have to deal with the root. And as we drill down to the root, sir, a lot of these things fall within the line of poverty, cramped housing areas. And as you go deeper, because there's deeper roots, and I have discovered this over the last few years, parenting being a major one. But as I have been able to drill down even more, dealing with high-risk individuals, there is a lot of childhood trauma in this country. There's a lot of unresolved trauma in this country. And these are not excuses being made for anybody. These are explanations. And these are social determinants of crime. Thank you, Honourable Member Sir St. Michael North. Brilliant man. And this is why these bills, I think, are excellent and well-timed, because they treat to the root and not just the fruit. Because I think I've said in here already, many people in here, whether I admit it or not, I know summertime, when I went and teach somebody fruits. And I know that by the blossom, you know, yes, Honourable Member for St. Philip West, he knows about agriculture. St. Philip South, sorry. And you will know that the fruit does grow back. Again and again and again. The only way to stop that fruit, the Minister of Agriculture will know what I'm talking about better than anybody else in the house. The only way to stop a bad fruit is to deal with the root. And the root is about caring. How do we care for our young people? Protection. How do we protect? How do we prevent instead of looking for a cure? How do we dispense with modern day therapy, art therapy, music therapy, pet therapy, animal therapy? When these facilities are formed, My contribution and my advocacy goes towards to make sure that we have the therapeutic framework to ensure that there is treatment to the root causes of the issues that find the people in the facility in the first place. And that is very important. Even when you think about those who've gone through the system, who've gone through various aspects of trying to address their behavior problems, and we look at this whole issue of discipline, and the Honourable Member for Christchurch so had it right when he talked about discipline. In the past, when we think about discipline, we think about some few lashes. That's what we saw as discipline. But the truth is, discipline is really getting people to do what they ought to do. And I have found in my own practice and my own experience that positive reinforcement works better than negative reinforcement. And I've always highlighted the case of my training to be able to train dogs and train horses. And I say, you know what? Not derogatory to humans, but I think the concept remains the same. If you're training dogs and horses, different animals, and you train them with lashes, when you raise your hand and be hey, shy, they can run from you, they can't operate. But how do drug dogs get motivated to go and find drugs? Because when they find the drugs, they're rewarded. Same thing for all the different types of training. I think it is more important for us to reward our children with positive reinforcement, ensuring that when they do well, that they are rewarded, so that the others could understand that doing negative ends up with negative reinforcement, and when you do positive, there's positive reinforcement. Whether it be a reward, whether it be a simple hug, whether it be a well done, or good and well child, son, daughter, whatever the case may be. Mr. Speaker, sir, as I said earlier, I'm going to turn to specific sections that I want to highlight for the public, for them to even take a look at the particular bill to see where we are being revolutionary. And I think it is time, we have an educated society, that more members of the public start to read these pieces of legislation. Because the things that I see on social media, when I do see it on social media, are the things that I hear being talked about versus what I know I sat and listened to and went through. There's a serious divorce, Mr. Speaker. And I think the only way we can correct that is not by shouting at the top of our lungs in here, but that we encourage the public to go and read for themselves. Any religious person will tell you back in the day, even with the religious texts, it wasn't popular for people to be able to read, so it was left for the pastors and the priests to interpret for you. But in the 21st century, we have 98% literacy I've seen in many studies. Therefore, I think the most important thing for us to do, sir, is to encourage the public to take a read for itself. And it may look intimidating, but once you start, you will see that you recognize the words and you could understand it. I turn, sir, to section 34 of the Child Justice Bill that speaks about the diversion. And the diversion is important because, as before I said, we had one remedy, and that was a big stick, whether it is small, medium, or large infractions. But now we have a system, and many a magistrate has raised this with me, even the one sitting on the bench dealing with juveniles now. Many a times cases come before magistrates, and they want a different option. They don't want to lock up the child. They want something else that they can do. By law, they now have all of the tools in their toolbox to ensure that they treat right by the children of Barbados, sir, because of this legislation. Mr. Speaker, sir, I would like to move on to section 54 that talks about restorative justice. And why restorative justice plays a major role for me in this whole idea of child justice, care and protection and crime prevention is because there must be outlets for people to say, I am sorry. There must be outlets on rehabilitation and reintegration allowed within the framework, because for me, for you, you offend me, you burst my head and take my phone, mash up my phone, and I just say, sorry. That is all good and well. But if there's opportunities for mediation, if there's opportunities for you to repair the damage that you caused, for me, that is healing on both sides. Because a lot of times within the criminal justice system, we would recognize that we speak a lot about the criminal, but there's very little talk about the victim. There's very little to address the victim, Because once you have a crime, you're supposed to have a victim. And once you have a victim, there must be ways to treat to the victims. And I think that the restorative justice speaks to the victim, but it also speaks to the rehabilitation of the perpetrator. So this is something that I want to see be able to mushroom coming out of this legislation, finding itself in regulations and policies and standard operating procedures of the agencies that deal with these matters, sir. The other thing that the last one I'm going to highlight on the child justice bill is something that I have spoken about and I've heard a lot about throughout the calling program career, and that is parent accountability. And you feel they're left out, sir? No, sir. In section 63 speaks about how do we get parents to be able to understand their role and accountability to their children, particularly those that are minors. So the bill is wide sweeping, and it answers a number of questions that have been asked by the society for the last 30 years. So that is why I can stand here confidently and comfortably, sir, and give my full support to this legislation, understanding that it is the right legislation for the right time, for the right target. And that is what brings me great comfort. Now, I remember the Honourable Member for St. Michael South, when we were going through these bills clause by clause, I remember the weekend meetings. I remember those 7 and 7:30 meetings that we would get with the same Faith Marshall Harris that he spoke about and others to ensure that we got it right. So it was not no rush job, no wham bam, thank you ma'am operation. It was a very deliberative, and collective operation to ensure that every aspect that all the agencies were seeing were being treated to and addressed in a fulsome way and not in a patchwork way that we have tended to do things in the distant past. So I am very, very happy about that. Now, understanding that hurt people, it is important that we treat to child justice and care and protection together. Because if you have a situation where you have a child coming into the world, facing neglect, facing abuse, going into a facility just to be secured or participating in infractions, and there is no mechanism to ensure that you reduce that hurt, what is going to happen is that child will become an adult, and that child will go on to hurt others. So we're dealing now with prevention. And Mr. Speaker, sir, both bills speak to that. Now, as I said, I don't want to be long, so I'm going to the parole and all the different things that many people have been calling for. Many studies have been done, and it is time now to be able to put these things into action. And I'm sure that once this bill is passed, we put these things in action. I will close on this point to give members the understanding of the importance of everything that's happening here today. Previous to this bill and other initiatives, we had a situation when somebody misbehaves in school, they may get a suspension. And I believe it was the mid-90s, late 90s, when the Honourable Member for St. Michael Northeast was the Minister of Education. There was a statement that suspensions actually sometimes cause more harm than the initial incident that caused the suspension, because what you are doing is taking a child that is lashing out, acting out, and sending them home unsupervised. So the Edna Nichols Center was set up to deal with that. Now, as time progressed and cultures change, we had situations where children were suspended and sent to Edna Nichols repeatedly for a 2-week program, the same program over and over. So the persons within Edna Nichols reported to the ministry that it makes no sense, and rightfully so, a child going to Edna Nichols past 3 times, because they will come to Edna Nichols and they will be disruptive in Edna Nichols because they did the program 3 times already. So the disruptive and bored. And what happens to a disruptive, bored child? Only one thing, Therefore, we needed more mechanisms. So in our wisdom, we introduced the New Horizons School. And the New Horizons School was to take out those particular children who were habitual in disruption and have them in their own environment with the social work framework to ensure that they get the help that they need. Of course, I understand when that proposal came, I was listening to the various policy discussions on that. It was supposed to start at 15 and progress to 60. The sad reality is we're still around about 17 or so. But the point here now is, with this particular legislation and these particular bills, we now have the opportunity to close the loop. And what do I mean by that? We have the opportunity for diversions where persons can go into various other programs. We have the 2 facilities which could now speak to in a more holistic way. And I believe the discussion on that must go in a direction of residential and day release, because the numbers are way too much to have it just residential. And what we would do now is we would have the full circle gamut of services available to young people and people at risk of being in conflict with the law and people that need care and protection. So I believe that we've closed the loop within the school system with this legislation once it gets on its feet. And not only just in school, but also in the society. In the society, sir, we had a situation where people who are destined and seem like they're belligerent and must be in a life of crime felt as though there were no options for them. That this is my lot in life. I am a gangster for life. I can get rich or die trying. And they perpetuated a sense of violence, a sense of lack of safety within our society. Through the Office of the Attorney General, Crime Prevention, which I have the privilege of helping to assist and manage, and through other agencies, particularly the Ministry of Youth, you've seen a dynamic, a transformation or the start of a transformation where a number of opportunities are being offered to some of the secondary risk level persons and tertiary, which are high risk individuals, persons exposed to some moderate amount of crime or people involved in crime, to say, listen, in terms of crime in this country, the law enforcement and court will deal with you. But if you are willing to not get involved in crime and you want to change your life around, there are options. Because some of them, and that's why I thank God for the education transformation, some of them set the 11 plus, sir, and they will be first to tell you, throughout the entire life, they felt like failures. And they act out the feeling of failures. So I got an education, I can't get a job, so then my way in life, the lane that I'm choosing is to go down a life of crime. But now that society has matured and transformation is here, we see a situation where persons can decide, I can get involved in this particular training program that can see me get a job at the end of the day. I can get involved in this sports program that I may be able to get a scholarship I was never able to get before. The bottom line is that we've opened up options to ensure that we have a holistic opportunity available for every Barbadian. And that is what our role in here is as legislators, to ensure that we make sure that there's a better life for all in Barbados. And with those few words, I could commend this bill and this report because, as I said in the beginning, I shall say in the end, this is a demonstration of not just talking the talk, but an administration prepared to walk the walk. I thank you, sir.
Honourable member for Christchurch West.
Thank you very much, Mr. Speaker. I hereby move that this honourable chairman be suspended to 10 minutes past 2 for the lunch hour.
Second.
Question is that this honourable chairman be suspended until 10 after 2 p.m. All those honourable members in favor, please say aye. Those against, please say no. We think the ayes have it. This honourable chairman stands suspended until 10 minutes after 2.